Okay, so let's talk about really what we're talking about here is the types of evidence that courts are allowed to consider when there is a contract dispute. All right. Um, I will say that it is that most contract disputes are handled outside of the court system. Um, and really, that's because business moves on, right? Litigation is expensive. Um, Oftentimes the disputes are with people who you may have business relationships with, and the relationship and future productivity stemming from that relationship is more important than the dollars at issue in a particular dispute. So this area of contract law is one that we do see cases, usually when they're cases when the dollars are sufficient, are significant to the point where the parties need to make a big deal out of it, um, or the business relationship has ceased to exist, or is not one that either company is relying on, or at least the litigant, the party suing, is relying on for future business advantage. Um, but that's just generally because Apple and Samsung have been suing each other for um, years, right? In multiple lawsuits, and they're still business partners. In fact, um, interesting, Apple can't make an iPhone without Samsung, right? And Samsung's biggest customer is Apple. So there's some interesting things there, but generally speaking, ending up in court is um, the last resort often for companies. So let's talk about the types of evidence that can be considered. Um, and Parol evidence really just means oral evidence, but actually we're talking about evidence that is external to the contract. So let's start with the idea that contracts fall into two buckets, right? Either they're fully integrated or they are partially integrated. All right. So when a contract is fully integrated, all that really means is that the contract is the totality of the agreement between buyer and seller. There was no contemporaneous oral negotiations that didn't make it into the written document, right? And I will say integration clauses are common if you ever go to buy a used car, or really any car, but I'll just say used car for this example. The salesperson is going to say a lot of stuff while you're looking at the car, inspecting the car, but then when you sit down to sign a sales agreement, there's going to be an integration clause, which means that if you're relying on anything that the salesperson told you as part of the agreement, it has to be in that document, right? Because it's pretty standard for sales agreements to have an integration clause, which pretty means anything I've said, anything the salesperson says during negotiations is not part of the contract if it doesn't end up in the sales agreement. Okay. So with partially integrated contracts, this could be something as simple as a memorandum of understanding, or it could be a document that is fully that would resemble a contract but lacks an integration clause. All right, which means that courts are allowed and will consider evidence external to the writing to determine what the terms of the contract were. What other evidence? All right. Well, I referenced oral negotiations, oral agreements contemporaneous or at the same time as the written agreement was signed, that can be a type of evidence that courts consider. But under the UCC, we're going to focus more on course of dealing, course of performance, and usage of trade. Let's take course of dealing and course of performance kind of at the same time. All right, so we're looking to the dealings between the parties, right? And the only difference between the two is that course of performance deals with the contract at issue. If it's a longer term contract or an installment contract where we have a course of performance under the existing contract, we're going to look to how parties have acted under the existing contract to determine how to deal with the dispute. All right. Whereas course of dealing, we're going to look to previous contracts, previous agreements. How have these two parties traditionally handled their business, right? Both look to consistency, are based on the assumption that people are consistent in their operations. Obviously, course of performance is a bit stronger evidence because that results from the contract at issue. Whereas course of dealing is similar contracts in the past. But you can change contractual provisions, but it still would be persuasive. All right. Uses of trade. Industry accepted terms will prevail. All right. I believe the example in the text is that of a 2x4 doesn't actually measure 2 inches by 4 inches. Right. And if you've ever put anything together or framed anything, you know that, right? It's common that 2x4 doesn't measure 2 inches by 4 inches, right? That's an example of usage of trade, right? Another example, barrel of oil. Well, a barrel of oil is a specified number of gallons. So if we sell 15 barrels of oil, or we agree that I will sell you 15 barrels of oil, and I show up with half-size barrels, that's a violation of the usage of trade, right? It doesn't mean I can't sell those half-size barrels. It just means that I need to specify exactly what I'm selling. I can't refer to it as a barrel of oil if the industry standard is one thing and that's different than what I'm selling. Okay. So when we think to why the UCC was created, it was created for uniformity and to give buyers and sellers of goods an expectation of what law is applicable when transactions go across state lines. Well, the same problem exists across national borders. All right. And so a similar convention occurred, in this case hosted by the United Nations, the Convention on Contracts for the International Sale of Goods. That is a mouthful. We'll say CISG. And the result of this convention, and this convention is fairly young as laws go. It was signed into law in, I believe, 1980. So 40 years, which doesn't sound young, but as laws go, it is pretty young. Is a treaty, right? And I'm not going to take you back to your civics class, but there's the process. Treaties are agreements with other nations, other countries. And treaties are a very high source of law. In the United States, treaty law is superior to every type of law except constitutional law. All right, so obviously, if in a sale of goods, the CISG, the convention, contradicts with the UCC, the convention would take precedence. All right, so it's a treaty between the United States and over 70 other nations, really representing close to 89% of the world's economic power. So it's pretty much the standard for international sale of goods. And the objective was to have a level playing field for international sale of goods transactions. And it does that. There are some pronounced differences between the CISG and the UCC. All right? And we could do an entire course on the differences, but I'm going to focus just on several, the three that we have on screen. So, CISG does not apply to consumer transactions. All right? As an example, if I transact to buy baseballs from the state of Kentucky, I'm a little league coach and I want to buy 100 baseballs, and I have them shipped from a seller in Kentucky. The UCC applies to that transaction. However, if I buy baseballs from Windsor, Canada, all right, the Convention for the International Sale of Goods would not apply to that transaction because I'm a consumer. So the CISG really only applies from transactions from manufacturer to wholesaler that cross international borders, and it would have to be international borders between companies that have signed onto the agreement. I will tell you, Canada and Mexico have both signed on, right? So the CISG is going to apply to manufacturer to wholesaler transactions that cross international borders. It's going to apply to wholesaler to retailer transactions that cross international borders, but it would not be applicable to retailer to consumer transactions that cross international borders. The mirror image rule is applicable, so additional terms are not recognized under the Convention for the International Sale of Goods, which is a pretty pronounced departure from the UCC. The UCC Battle of the Forms does not apply. All right. Perhaps the biggest distinction is the lack of a writing rule for any contract. And the reason being is that is how most of the world does business. So when the United Nations, or I should say at the convention, it became apparent that most of the countries that were going to be asked to sign on to this treaty don't require written contracts. And in fact, it's even faux pas in some countries to suggest that we write down our agreement. It promotes distance and distrust in a business transaction. And it is not possible to do business that way, quite frankly, in some countries. So for that reason, there's no writing requirement under the CISG. Okay.